My name is Amy Gari, and I am applying for the position as a Junior Legal Officer at the Office of the UN High Commissioner for Human Rights and State Sovereignty, or the OHCHRSL. The following video will outline why I believe I am the most suited for this position, why I am passionate about working with The Hague, and my knowledge and expertise surrounding the 2017 National Constitutional Convention. Firstly, a bit about me and who I am as an individual. I am a newly admitted legal practitioner of the Supreme Court of Queensland here in Australia as of 2019. I currently reside and work full-time here in Queensland, and I am passionate about all areas of law, but specifically surrounding international conventions and the protection of universal human rights. In 2017, Aboriginal and Torres Strait Islander delegates united at the 2017 National Constitutional Convention to produce the Uluru Statement from the Heart, a statement that, among other things, requested for a First Nations voice to be integrated into the Australian Constitution. The statement gained countrywide support and recognition as Aboriginal and Torres Strait Islander Social Justice Commissioner June Oscar called out for a constitutional reform. In response to this convention, Parliament appointed the Joint Select Committee on Constitutional Recognition relating to Aboriginal and Torres Strait Islander peoples, who, as of late last year, submitted a report that considered the needs being demanded and created clear recommendations for constitutional change that satisfied all key stakeholders. Basically, it was the goal of the report to find a clear common ground and negotiate possible pathways that Parliament could take to ensure the voice of the Indigenous was recognised. The desire for a First Nation voice being enshrined in the Constitution is obviously evident from an Indigenous perspective. It comes from a dream of controlling one's own destiny, so to speak. The famous statement from the Uluru Statement, which says, "We seek constitutional reforms to empower our people and take a rightful place in our own country. When we have power over our destiny, our children will flourish," became the backbone for the final report by the Joint Committee. And with the release of this statement, clearly a countrywide support has been demonstrated through media, with Aboriginal individuals such as Gary Oliver, the CEO of the National Congress of Australia's First Peoples, Eddie Steiner, an Indigenous researcher at Griffith University, and Tila Reid, a Wiradjuri lawyer and human rights advocate, writing about the shared hope for a common ground to be found between the Joint Committee and the federal branch. In his written letter to disagreeing politicians, Oliver himself wrote that all we want is for our histories, cultures, language, and rights to be known, understood, and honoured. We want to be recognised as the first Australians. We want the right to self-determination, control over our lives, and the power to determine our own future. In the final report, the Joint Committee suggests that it is possible to have a successful referendum if put to the Australian public based on precedent. The 1967 referendum was the most successful in Australian history, with a 19.7% majority vote in support of Aboriginals being involved in the race had a power in the Constitution. This was then compared to the failure of the 1999 referendum, which looked at determining if Australia should become a republic. This vote, on the other hand, gained a 60.7% majority vote against the idea. It was believed that bipartisan support was one of the backing reasons why the 1967 referendum was so successful, which is recommended as a necessity by the committee in discussions. Based on these statistics and the unofficial support gained through media in response to the Uluru Statement, anyone could predict that there is a clear, high likelihood of success. But in the case of potential failure, the committee recognised the potential for a societal blowback to Indigenous citizens and instead mentioned an alternative option: establish a parliamentary voice through legislation first, then aim to enshrine it officially in the Constitution later on. It was even recommended by Lorraine Finlay, the former president of the WA Liberal Women's Council and an expert in constitutional law, that having a legislative enactment of a First Nations voice may even increase public support, as the opportunity to see how this voice in particular would function in the federal branch parliament may be insightful for the public, an argument that the Indigenous People Organisation agree with. However, one of the opposing arguments from the Prime Minister was the potential inconsistency the First Nations voice may create with civic rights in Australia. From his perspective, having a specific voice may negatively affect the federal balance of the Constitution. Based on the race head of power, however, legislation requires for there to be a kind of special law that discriminates against all individuals except for the subject matter race, as briefly outlined and explained by Justice Stephen in the founding case of Kuata and Belky Peterson. If we treated the First Nations voice as a piece of legislation that needed to be validated against the Constitution, it would hold up. The voice would be specified for Aboriginal and Torres Strait Islander Australians, and it would be a special law to guarantee the Indigenous Australians' say in their own culture of politics. But looking more so at the First Nations voice mainly as a political initiative and not as legislation, it's still difficult to argue against such a potent Indigenous right. Aboriginal Australians and any Indigenous race of any country for that matter are entitled to respect and a public recognition of their own original presence. While not legally binding in Australia, the United Nations Declaration of Indigenous Peoples, which is signed by Australia, affirms that while they are all equal, they also should be recognised as different and respected as such. Article 3 specifically says that they have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development, while Article 18 describes having the right to freely participate in decisions that influence and impact their individual rights, and to do this through representatives chosen by themselves in accordance with their own procedures. Even the International Covenant on Civil and Political Rights, or the ICCPR, which is also signed by Australia, discusses the right to freely determine their political status and to general political participation. For there to not be equal representation of all Australians in Parliament would be the true imbalance of civic rights. It is the entitled right of Aboriginal Australians to have a federal Aboriginal leader who can decide rightfully for the benefit of their culture, heritage, beliefs, and safety of their people. This is what the voice would be built to do and is the purpose of the recommendations made by the Joint Committee, and this is why it has my personal support. As an advocate in human rights, I pray that someday Parliament realises that it is in their best interest to find a common ground and to be able to satisfy the traditional owners of the land that we take so much advantage of. Self-determination is a vital right to reality, as I am sure the Hague is aware of, after all. I hope this presentation has proven to be insightful, if brief, in who I am as an individual and a lawyer, and who I could potentially be as a member of your junior legal office team. I am extremely grateful for this opportunity, and I look forward to someday working with you in the future. Thank you, and goodbye.